This is Civics, Chapter 7, Section 4, Landmark Supreme Court Cases, Part 1. So what is a landmark Supreme Court Supreme Court case? Well, it's a Supreme Court case that has a high level of importance and has a great significance that has a lasting effect on American individual rights and liberties. It's something that really affects the United States legal system, and it usually makes something illegal or makes something legal according to the Constitution in the United States. The landmark Supreme Court cases really show the power of the Supreme Court and its effect on Americans. So, this first one, it's a little dry. It's a little complicated, but try to simplify it. This happened all the way in 1801. It's Marbury versus Madison. The second president of the United States, John Adams, newly appointed many new district judges on his last week of his presidency. He had lost the presidential election of 1800 versus Thomas Jefferson, and he kind of wanted to do a few things and rush and do a few things before he had to leave office. And so he appointed all these new district judges, and they were called midnight judges because they were appointed at the very last minute. Remember in our previous sections that presidents have the right to appoint district judges, and that's what he was doing in his final days. Soon as President Jefferson took office, he was not going to honor all these last-minute appointments by President Adams. One of these judges that did not receive their promised appointment was William Marbury. He sued Secretary of State James Madison, and at the time, the Secretary of State was the ones that officially handed out the appointments to the federal judges. Marbury sued James Madison for his job that was promised to him by former President John Adams. So, the Supreme Court heard the case, and they concluded that the Judiciary Act of 1789 that allowed the Supreme Court to hear cases was an unconstitutional cases. So this Judiciary Act of 1789 that was passed that allowed Supreme Court to hear cases that were about federal issues such as this one was deemed unconstitutional. The Chief Justice at the time, John Marshall, explained that the Judiciary Act of 1789 was unconstitutional because Congress gave the Supreme Court powers that the Constitution did not list. So pretty much the Judiciary Act gave the Supreme Court powers that the Supreme Court deemed was not their right to give. The only thing that can give the Supreme Court power is the Constitution itself, not Congress. So the Supreme Court decided they could not hear the case and could not issue a ruling. So the only thing that the Supreme Court can do is things that are listed in the Constitution. So Marbury versus Madison. It started out with just this guy wanting his job, and it kind of ended with a completely different outcome, completely different ruling of what was going on originally. But the Supreme Court ruled that the main purpose of the Supreme Court, per the Constitution, was to review cases and decide whether the law in question agrees with the Constitution or does not agree with the Constitution. The Supreme Court said that they don't have the power to decide who gets to have a job or who doesn't, all because Congress wants them to decide. So, the importance is that the Supreme Court establish what they can do, and what they can do is use judicial review to review cases and judge them against the Supreme Court. That's the importance of Marbury versus Madison. And eventually, Marbury, since the case was not able to be discussed in the Supreme Court, Marbury Law never received his appointment. All right, the next one's a lot more clear. This is Tinker versus Des Moines. This is 1965 in Des Moines, Iowa. A 13-year-old student, Mary Beth Tinker, wore a black armband to school in protest of the Vietnam War that was happening. Other students began also wearing the armband to join the protest as well. The school board was informed of these students protesting the Vietnam War by wearing these armbands, and they established a rule that they could not wear these armbands in school. Tinker and other students, next time they came into school, they were asked to remove the armbands and were suspended for their not following of the new school rule. The students were told to return to school or to not return to school unless they were going to not wear the black armband. So, the students filed a lawsuit believing that the school was violating their First Amendment right of freedom of speech. After 4 years of going through the federal legal system, the case did reach the Supreme Court. So during the 4 years, Tinker and other students did not wear their armband to school, but they wore all black every day to follow in their protest, and the school couldn't really stop them from doing that. So the Supreme Court constitutional question at the time for this case was, does the banning of wearing of the armbands in public schools as a form of symbolic protest violate the students' right to freedom of speech? Well, the Supreme Court decided 7-2 that yes, the Supreme Court, the school district was in the wrong, and they were in fact violating the students' First Amendment right to freedom of symbolic speech. The majority opinion explained that school officials can only limit the freedom of speech in schools if the article of clothing interferes with the day-to-day learning or operation of school, and they deemed that in this case, the black armbands were not preventing students from learning. Things that would prevent students from learning is maybe a curse word on a t-shirt that would be a distraction and offensive to some people in the learning environment. But in this case, wearing the black armbands was okay in schools. So, the next Supreme Court case we kind of touched on earlier when we were going through the Bill of Rights was Arizona versus Miranda. And this happened in 1963 in Arizona. Ernesto Miranda was arrested inside of his home and taken to the police station, and he was charged with a kidnapping and rape. After being questioned 2 hours once at the police station, he finally broke down and gave a written confession. The confession was used in court to convict Miranda of all charges against him. Miranda's defense attorney argued that Miranda, who was not properly educated in the United States, and argued that he did not know his Fifth Amendment rights that protected him from forced confessions and the right to an attorney. The Arizona police did admit that they did not inform Miranda of his rights to not give a confession. The state courts in Arizona dismissed this argument, but Miranda and his defense attorney took the case to the Supreme Court. The Supreme Court question was, does the Fifth Amendment's protection against self-incrimination extend to the police interrogation of a suspect? So, pretty much, does the Fifth Amendment protect Americans against police asking questions in interrogation of a suspect? Well, the decision was narrow, with a 5-4 majority favoring Miranda. And the argument was that the law enforcement needs to inform their citizens of their rights when they're arrested. This safeguards the citizens' rights and makes it very clear to citizens when they are arrested that they have the right to remain silent to prevent themselves from self-incrimination. Any confession deemed afterwards is okay as long as they were read their rights. But if they weren't read their rights, they cannot use that confession in a court of law. So, this is why the rights read by police officers during arrest are called Miranda Rights. Miranda was retried in Arizona for his crimes and still found guilty, even without the confession. So, good for civil rights in that Americans that maybe are not educated, not know their rights, are read them before they are arrested, and can protect themselves from self-incrimination. But not so good for Miranda because he was found guilty. It was pretty obvious. And so this is the full Miranda rights that you have to be read when you are arrested. You have the right to remain silent. Anything you say can be used against you in a court of law, meaning that if you're going to say something, it's going to be used against you. So it's best that you just don't say anything. And I highly recommend anybody that's arrested, just don't say anything when you are arrested. You do not have to answer the police's questions. You have a right to a lawyer. Especially don't say anything until you have a lawyer present. And if you cannot afford a lawyer, one will be appointed to you. If you do decide to answer a question without a lawyer, you have the right to stop answering at any time. So the police will still try to question you. The police can still question, but it's up to you just to remain silent. So the next Supreme Court case that has massive implication for Americans' rights is Roe v. Wade. It's 1969 Texas. 21-year-old Jane Roe requested an abortion, which is a termination of a pregnancy, but was denied by the state of Texas. At the time, the Texas state law decreed that only legal abortions involved rape or the health of the mother, meaning that if a victim was got impregnated because of a rape, they could abort the baby, or if the mother was going to die, if the baby was not terminated, they could abort the baby. So, Jane Roe was neither raped or had health, or her health was in immediate danger. Therefore, she was denied her to receive an abortion. Henry Wade, the current Texas District Attorney, was attempting to protect this Texas state abortion laws against Jane Roe. So, Roe and her attorneys argued that Texas state laws were unconstitutional and went against a lot of amendments, 1st, 4th, 5th, 9th, and 14th of the Constitution, especially the 14th that protects a person's privacy law. Roe versus Wade went through the federal courts. They lost both cases until it reached the Supreme Court. So the interesting fact back to this case is that it does take years before a case goes to the Supreme Court. When Roe first started her case, she was currently pregnant, and obviously it only takes 9 months to deliver a baby, so she actually had her baby before the case was even over. So even though it was kind of a moot point at that, it was a big deal because it would set precedent for future abortion laws. So the Supreme Court questioned, does the Constitution recognize a woman's right to terminate her pregnancy by abortion? Supreme Court decision, 7-2 in favor of Roe, saying that Texas state law did in fact go against the U.S. Constitution. The majority opinion explained that Texas state law was unconstitutional because it was too broad in the limitations of women's right to privacy, and abortion falls within this category. So, in the 14th Amendment, any state should not deprive a person of their life or liberty, which is their choice, or property. So, saying that a woman could not have an abortion went against their liberty, their choice to do so. However, the Supreme Court did say that the states can't implement very specific laws to protect human life and ban abortions in some instances, such as third trimesters where the baby could survive out the mother's womb. So that's still pretty. So each abortion case is very specific. So a woman, if the baby could survive outside the womb in the third trimester, they cannot receive an abortion at that time. So even though abortion laws have, after Roe versus Wade, have definitely loosened up, and that's the importance of Roe versus Wade, that abortions became widely legal in the United States. There are still some laws that protect the unborn baby. Still hotly contested. There have been many Supreme Court cases after that to try to overturn Roe versus Wade, but none have been successful. And the last landmark Supreme Court case is a Second Amendment case. And the background of District of Columbia versus Heller is that in 2008, Washington, D.C. Had a law that was passed at the Firearm Control Regulations Act, that prevented anyone in the city limits to own a firearm, to keep crime down in the nation's capital. Dick Anthony Heller, a Washington, D.C. police officer, wanted the ability to keep a handgun at his house, and he applied for a special license to do so. His request was denied. Heller sued Washington, D.C. in the federal district courts, stating that the Firearm Control Act went against his Second Amendment right to bear arms. The district court did not agree with Heller, and he was again denied owning a handgun. Heller then took his case to the Court of Appeals, where they ruled the Firearms Control Act did infringe on his Second Amendment. Washington, D.C. took Heller to the Supreme Court, and the Supreme Court did accept the case, and the question was, does Washington, D.C. Laws that restrict gun ownership kept in the home violate a person's Second Amendment? And the Supreme Court narrowly decided in favor of Heller, that yes, the Firearm Control Regulations Act did go against the Second Amendment. And the reasoning was that the whole purpose, they interpreted the Second Amendment that the purpose of the Second Amendment is to give citizens the right to protect themselves from the government. So if the government says that the United States citizens cannot have guns, then they have lost that right guaranteed to them by the Constitution to protect themselves from the government. Or, in Heller's case, he wanted to protect himself from confrontational danger because his neighborhood became unsafe. So, it is unconstitutional that the government, only government employees can have access to firearms and not American citizens. It is now legal to own a firearm in D.C., but there are many restrictions, and you have to get many licenses to do so. So it's not exactly easy, but you can have a handgun in Washington, D.C., but it's very hard to do so. All right, that concludes Chapter 7, Section 4.